Obviously, it's a legally enacted law. I think there should be deference to the legislative process. I understand the governor vetoed it, but that's part of the legislative process. I think there's a general concern, just stepping outside that issue, with statewide injunctions by a single common pleas court judge. We have the same problem with a single federal court judge issuing an injunction with federal legislation or a federal executive order. So, we'll have to see what the basis of the judge's ruling is, why they're doing that. But, we certainly don't, I think we've gone down the path on many occasions of these things, of constitutionally enacted laws being set aside by a single individual judge. If that is so, well, it is so, hopefully that will be resolved quickly. I would frankly be in favor of changing the law to say if a judge does that, and for the entire state of Ohio, a single judge elected in a single county sets that law aside, whether it's Franklin County or Williams County or wherever it is, that's immediately appealable to the Ohio Supreme Court, because otherwise essentially one person is doing that. And if it's resolved quickly and it can be appealed either to the local court of appeals, wherever it may be, at the Supreme Court, it's one thing. But when there are temporary restraining orders that go on and then penned for months or years, it's effectively defeating the constitutional process. I would compare it, frankly, to what happened in Colorado. A Supreme Court of a state decided to effect a federal presidential election, in that case based on their interpretation of the federal Constitution. These are federal elections, and so when states do things, whether it's for U.S. Senate, Congress, and the president, the federal courts necessarily step in. So that's part one. Part two is there's a reason why this 90-day law is in effect. For those of you who follow these election laws closely, we have early in-person voting 30 days, but we have to mail out overseas 45 days. There's a period of time before that when the ballot has to be prepared, and the law says everyone gets 10 days to inspect the ballot, make sure their name's spelled correctly, all of that. So as you count back on that, you get into about day 60 or 63 when they have to know who the candidates are. Now, and I don't know the actual number, so at some point somebody said, tell us 90 days beforehand, federal, national political party, who your candidate is. So there's a good reason to do that. But I think it's likely that if a state law, whether it's this one or state action like Colorado and Maine, that will keep a candidate of a major political party off the ballot, then ultimately a federal court and perhaps the United States Supreme Court would move in and do something about that. So, as I've said before, Secretary LaRose told me about this. He said, hey, I'm going to send out a letter to everybody because we don't want to wait till August and it's too late and everyone's taken by surprise. So he proactively did that, which is his job to do that. And at least at that point, the National Democrats didn't know about that. I don't know if I certainly didn't know about it, so I'm not. But the manner in which that's done, I don't think it's incumbent upon me to guess what they're thinking. That, well, we're going to introduce this bill. Hey, wait a minute, it needs to say this, not what you're doing. So I'm as I mentioned in my previous remark, they're going to bring us something, and I think we'll try to resolve it here in the next couple months. I think the answer is we want to know what they want us to do. And I think there's actually another example, maybe in 2012, right? And that was a Republican convention, or I don't know. Anyway, this has happened before, so I think it needs to get resolved. And for folks who say, well, we can keep Joe Biden off the ballot, that's wrong. I think you're not going to be able to look at the current president of the United States and a major political candidate and just say, we got a law, you didn't know about it, ha ha. And by the way, I mentioned this too before, there's nothing magic in the law in the state of Ohio. Some of you may be able to correct me right now, or somebody else may be. about a convention. We get informed by national parties and other actors through a variety of matters. The national committee right now could pass a resolution and the chairman send it to the Secretary of State and say, Joe Biden's our candidate, and that's it. And I think that's even more true these days, and especially now, including in this convention, where they already know who their candidate's going to be. I mean, unfortunately, I think since 1972, most political conventions have turned into 3 or 4 day demonstrations of power or whatever it is that people are trying to demonstrate. So we know who the candidate is. The Democrats could just tell us, and we wouldn't even need legislative action. So it's going to get resolved. But I don't want to speak on behalf of the Democratic Party. Not a member, but we're certainly going to try to accommodate getting it resolved in the way I described here. So I would not say optimistic, but I am reasonably hopeful, if you need words, that we can get something done by June, because I think most reasonable people, including people in the industry, believe that it would be better to have it clarified in law. The other part is whatever, and I don't know enough about the subject matter of the proposed regulations to comment on those, but one of the problems with bureaucracies issuing rules is a legal challenge saying you don't have the authority to do that. And that's why oftentimes, really with all significant legislation we pass, there's enabling clauses like, we want to do X. Department of such and such is responsible or empowered to go out and issue rules and do these things. And then the legislation, the legislative input on that is the Joint Committee on Agency Rule Review, largely made up of legislators to say, yeah, that's what we meant. Well, we didn't mean that. So, I think, I'm looking that there will be some legislative action here before we leave in June. I do think that, one of the things that was brought to us regarding the taxes, and I'll just comment, were the fact that with greater access to marijuana, there will be more visits to poison control centers. So the children's hospitals came to us and said, in Colorado and Michigan and other places, the number of visits of children to poison control centers, often at children's hospitals, will go up this much. That's what the data shows, and that's a $15 million bill. Well, that's part of what we did in December. And if, that's really important that we fund that. And now that's part of redoing the package of how the taxes were passed. But there's other things I think, that are in that. So I'm just commenting on the taxes because you brought it up. And the home grow situation is a problem, as people have mentioned, because it essentially will create a business in the home, because what folks are allowed to grow is far beyond personal use. So let me just finish my answer, and I'll ask you another one. So if you ask me what's most pressing, I think what's most pressing is people smoking marijuana when they're walking down the street and stop at a stoplight, and there's, as the governor described, 2 kids and their parents going to a baseball game, and they're inhaling marijuana smoke. So maybe if there was one thing but I think there's too many things that are part of our proposal. Something becomes legal, which this wasn't until December 7th, so we're only 4 months into it. People begin to say, hey, that's what my buddy down the street is doing, and he's selling to everybody in the neighborhood. I can sell to people in the neighborhood, and I got people at work, and I got, on and on. And who else is they going to sell to? Well, they're going to sell the kid who shows up at their house and says, I'm 21. Well, maybe they are or not, but, I mentioned I was in Ashtabula a few weeks ago, and they were talking about the problem in that town, and that a 25-year-old had just died, bought marijuana from somebody, and it had fentanyl in it. Now, and he died as a result of that. Now, all of that could happen anyway, but because there are so many people now empowered to grow marijuana and sell it, without a license, without doing it, it's like any other substance that you put in your body. If suddenly somebody started saying, hey, look, I'm going to start selling milk, but I'm not going to go get a license, I'm not going to do anything like that, well, do we know that that's all the things you have to do to make milk safe? So whether it's drugs, whether it's food, whether it's alcohol, whatever it is, and I would put marijuana certainly in a category of dangerous substances in and of themselves that need to be licensed and regulated. And that's the most urgent thing is the danger, you know, the smoke in public places and all of that. It's like, you gotta be kidding me kind of thing. But it's really just a danger to the public. That, again, is inherent in any substance that someone is putting into their body.